Namaste friends, welcome to my channel. This is your Govindraj. You all have made us proud with your response to our previous video. Today I have come up with another update on the Code on Wages Central Roles 2020, which is the Ministry of Labour and Employment notified for the public for objections and suggestions very recently. See, the first draft was released by the Ministry on 1st November 2019, and we all have submitted few objections and suggestions to this draft as well. However, friends, do not ignore this update considering this as a central rules because it has practical importance for all of us, as the central government alone has the power to frame rules on some of the key provisions of the code. Therefore, it is equally important for us to read these rules also and understand in addition to the state rules which are going to come in the days ahead. Friends, before we get into some highlights, we need to know certain prior information for better understanding of the provisions of the draft rules. First thing is, let's understand what is the necessity of framing rules when the code or act is passed by the parliament or by the state. See, when any act or code is passed by the parliament, it contains certain abstract provisions and key elements. However, if you look at the implementation part is left to the appropriate government. See, this appropriate government will be both central government for all industrial establishments who are under the control of the central government, and in all other cases, of course, the respective state government in their respective jurisdiction. So we need to also read the appropriate government for a proper understanding of the sphere of control of central government as well as the state governments. Moreover, what I'm saying you is the law needs a procedure or implementation rules like working rules, authorities, forms, registers, administrative machinery, etc., which need to be developed by the appropriate government. See, if the act or the code has to contain this all these provisions, then that will become voluminous. And another point is that there will be some dynamic points which will change over time. See, these dynamic points are required to be updated, from time to time. Therefore, this needs to be taken care of by the rules instead of amending the entire act or the code. And also, the statute provides power to the appropriate government and sometimes to the central government alone to manage certain provisions by way of making rules. So that is why we need to understand the definition of appropriate government and what is the necessity of framing rules when the code or act is passed by the parliament or state. So which is important. Now let's get into some highlights of these new draft rules. See, these rules apply to the industrial establishments who come under the central government as appropriate government. However, and also in some cases like payment of bonus, floor wages and etc., the central government alone has the power to frame rules, as I said earlier. So in such cases, it applies to the entire country. So moreover, in all probability, the state governments adapt the same rules for their state with or without some minor changes. Therefore, it is important for all of us to read and understand the central rules for implementation and practical purposes. Now, let me address first what are the changes compared to the old draft and the new draft. See, in my opinion, if I look both the drafts, both old and new drafts, there are no significant changes. The new draft is more or less the same as the old one. See, I could not observe that the old one was published in the official gazette, but the new one is published in the official gazette. This means the government is serious to make it final. However, I could figure out only two changes compared to the old draft, which are, the first one is, see, the earlier draft rule 6, which explains the number of working hours which constitute a normal working day. This was contained 9 hours as the normal working day. So whereas the new rule has defined it as 8 hours. See, we all have also suggested the same, this change considering the norms in the State Shops and Establishment Act, Factories Act 1948 and other similar statutes. So this working hours, normal working hour per day, normally it is 8 hours in Factories Act as well as State and Shops and Establishment Acts. So therefore, we also suggested it to be 8 hours. Now the draft rules also contain this change. And the second change is by way of the addition of one rule while explaining what to do with the undispersed amounts due to death or whereabouts of the employee not known. See, when any employee dies or his whereabouts are not known, then his settlement or the dues have to be paid. So to whom it has to be paid and what is the process? Now the draft rules also contains the provisions about this. So rule 46 is now split into two rules to address two situations. Earlier only the rule 46 was containing this provision. Now it has split into two rules and to address two situations. Situation one is, rule 46 talks about it. what to do with undispersed amount or the dues when the nomination is made by the employee. So this is a new addition compared to the old rules, which says if the amount could not be paid to the nominee of the employee until the expiry of 3 months from the date the amount had become payable, then such amount shall be deposited by the employer with the Deputy Chief Labor Commissioner Central having jurisdiction, who shall also disperse the amount to the person nominated by the employee after ascertaining his identity within 2 months of the date on which the amount was so deposited with him. Now, this is the situation 1. So, let's see situation 2. So, in situation 2, Rule 47 of the Code on Wages Central Rules, 2020 talks about situation 2. So, this rule explains what to do with the undispersed amount or the dues when the nomination is not made by the employee. See, this is similar to as in the old draft. Therefore, it is retained as in the same old draft, which says if such amounts could not be paid to the nominee of the employee until the expiry of 6 months from the date the amount had become payable, all such amounts shall be deposited by the employer with the Deputy Chief Labor Commissioner Central having jurisdiction before the expiry of the 15th day after the last day of the said period of 6 months. See, however, friends, you may all know that most of the state governments have enacted labor welfare fund, and if all such amounts could not be paid by the employer until 3 years, such amounts are required to be deposited with the labor welfare fund. Therefore, wherever there are no such provisions, only this provision is going to come for application purposes. See, barring these two changes, at least for my mind, no changes could be observed which are important for us. However, let's see some of the key points which are relevant for us from the entire Code on Wages Rules 2020. See, as you know, when the Code on Wages 2019 was passed, there is no any scheduled employment concept going ahead in case of minimum wages, because the scheduled employment concept has been dropped in the Code on Wages. Therefore, the central government has listed all the occupations in Schedule E and also defined different skill levels, which are unskilled occupation, semi-skilled occupation, skilled occupation, and highly skilled occupation. So these are the definitions which are already given in the draft rules. Now, the central government, based on the recommendations of the technical committee, they can also add different occupations to the Schedule E going ahead, because the Schedule E contains all list of occupations. So if suppose tomorrow the central government feels some more occupations have to be added, then the central government is free to do so based on the recommendations from the technical committee. However, friends, it may be noted that the Code on Wages covers all employees, including managers and supervisors as well. And these occupations are not listed in the Schedule E. See, this is important information which we need to know. And maybe it requires more deliberation also. And coming back to zone or geographical area, now the rules defines 3 zones or geographies for fixing the minimum wages. So, which are, one is metropolitan area, another one is non-metropolitan area, and the rural area. So, if you look at today, the minimum wages notification, they are talking about either zone 1, zone 2, zone 3, or metropolitan area, or city municipal corporation area. These are the definitions you find it. Now, the draft rules talks about only 3 zones, which are metropolitan area, non-metropolitan area, and rural area. So, metropolitan area means a compact area having a population of 40 lakhs or more, comprised in 1 or more districts. And non-metropolitan area means a compact area having a population of more than 10 lakhs but less than 40 lakhs, comprised in 1 or more districts. And rural area means the area which is not the metropolitan area or non-metropolitan area. So, my conclusion is, if this concept is adopted nationwide, then probably the wage disparity between these similar zones or geographies may disappear, provided every state will adopt the same concept and they fix similar wages. And let's get into the next highlight or next important point for us. The manner of calculating the minimum rate of wages is incorporated based on the criteria declared in the judgment in Workmen represented by Secretary versus Management of Reptacos Brett, and also on the recommendations of the 15th Indian Labour Conference. So the standard working class family and the requirements of this unit are all captured as per the above recommendation. So that we can see some logic behind how the minimum rate of wages have to be calculated and what criteria has to be taken. So therefore, this component or this criteria is adopted now. And talking about floor wages, you also know that the central government can fix the nationwide floor wages or geography wise floor wages. Now the rules are brought on how the floor wages can be fixed and what is the frequency and who all needs to be consulted in this case. And also the revision interval is also set at not exceeding 5 years. And you may also know that the code on wages does not contain any schedules which are used for the computation of bonus. Now we will get into some highlights related to computation of bonus and the procedure related it. And in the code on wages, it was left to the central government to prescribe this computation of bonus and the schedules. It was left to the central government. Now the central government has retained the same schedules which were originally part of the Payment of Bonus Act 1965 with the revised numbering. Now Schedule A of the draft wage code rules describe the manner of carrying forward set on and set off, which was earlier the fourth schedule in the Payment of Bonus Act 1965. And the new Schedule B described the computation of gross profit in the case of banking companies, which was earlier the first schedule. And the Schedule C described the computation of gross profit in the case of companies other than banking companies, which was earlier the second schedule. Now, you can also know that the employer can deduct certain prior charges from the gross profit like direct taxes and depreciation as per the provisions of the code. And he can also deduct certain other prior charges which need to be prescribed by the central government. These other sums are now described in Schedule D, which was earlier third schedule. So these are the changes which are related to payment of bonus were brought in the draft code. So another important change or the clarity we see is the responsibility to pay bonus and wages to contract employees, because this topic was also much debated and not much clarity was available. Now I think the draft code has brought, and also the code on wages has brought some deliberations or discussion for this matter. Let me tell you what is the law laid down so far on these important topics. See, the law laid down by the judicial pronounced so far is that the principal employer is not liable for payment of bonus for the contract employees, considering the interpretation of employee, employer, and wage definition in the relevant statutes. You see, this situation will change due to the new provisions incorporated in the Code on Wages 2019. I will draw your attention to section 43 of the code, which mandates that if the employer, here the contract employer, fails to make payment of all amounts required to be paid under the code, which includes payment of bonus, then the company or firm or association or any other person who is the proprietor of the establishment, so here the principal employer, in which the employees are employed, shall be responsible for such payments. So if the conclusion of this provision is, if the contractor failed to pay all amounts due to his employees, and the principal employer is also liable to make such payments, which includes very well bonus, wages, everything. And this leads to another question, definitely. So the question is, what is the basis for the principal employer to make the payment of bonus to contract employees? Is the principal employer has to make the same bonus as applicable to permanent employees? See, this all needs a deliberation. So this also needs to be deliberated and further discussed, as the calculation of bonus is based on the profit situation of the employer. And probably to avoid this situation, the Code on Wages Central Rules 2020 has mandated the principal employer to pay a minimum bonus only when the contractor fails to pay the bonus to his employees. So that is why this provision has been brought in the new draft rules. So you can also look into this provision in the draft rules. And as I said, this needs further interpretation and deliberation going ahead once the draft rules are also finally approved and issued to the public for application. Now, I will draw your attention to another important point. See, the central rule, Rule 55, also mandates the employer to pay to the contractor the amount payable to him before the date of payment of wages, so that the payment of wages to the contract employees can be made positively by the contractor within the time limit as provided under Section 17 of the Code on Wages. See, this is the new addition to ensure that the contract employers get paid to make the payment to their employees within the time limit set. So probably the legislative or the executive machinery have observed this. Not every contractor have been paid at the proper time, and they must have also received some complaints that the contract employees' wages are getting delayed. So therefore, to avoid this situation, now this rule has been brought, and this mandates the principal employer to pay whatever has to be paid to the contractor within the due date, so that he can make the payments to his employees within the time limit set. So in addition to all the above highlights, I can say that the code has come up with simplified, uniform, and only two registers, being a single register for wages, overtime, fine, deduction for damage and loss. And there is one employee register also. In addition to this, of course, employer is also required to issue wage slip. This form is also provided. But important thing is I could not observe any returns which needs to be filed by the employer, which is a good move. These are the major highlights which we should know about the code on wages central rules, and I am not sure any major changes will happen even after the expiry of objection or suggestion period, as I could not see any significant change so far from the old to new draft. These are all the updates from my side, friends, on the new draft central rules on wage code. I will come up with more such updates in the future. Please permit me to sign off at the moment. If you like this effort and useful to you, please do share, like, comment, and subscribe the channel for more such updates. You can also revert to me in the comment box if you have any questions as well. Thank you all, friends, and stay safe.